hope you're doing well. We made it to OJ. I think today we just hear Marcia. I think it's just Marcia today. But it is closing statements. Oof. Oof, 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 oof. It's okay. I'm not sure how we left yesterday. He got mad about the camera and turned the camera off. But we're back today. So let's get going.
And let the record reflect that we've been rejoined by all the members of our jury panel. Ladies and gentlemen, my apologies to you for those interruptions, and my apologies to Ms. Clark for having interrupted her train of thought there. A couple of things happened that I needed to deal with immediately, and I apologize to you for the disruption in the thought process. We will go through at this point until 5 o'clock, and then we'll take our mid-afternoon recess. And however, I realize that since we're having extended hours, one or two of you may have a need for a comfort break. So if you do, just raise your hand, get the bailiff's attention, and we'll take a quick 5 or 10 minute break if you need to during the longer hours. Ms. Clark?
Good afternoon. Okay, we've talked about conduct, we've talked about opportunity and timing. Let's talk about the physical evidence. I'm not going to do it in the detail you've already heard it, heaven forbid. But although you've already seen, with the opportunity evidence, with the conduct evidence, we already have evidence to show you that the defendant did commit these murders without even really getting into the physical evidence. And once you see the vast array of physical evidence, you can see that there's virtually an ocean of evidence to prove that this defendant committed these murders. What all of it does, all of this evidence, is it links the defendant to the victims and the crime scene at Bundy. Now, the defense has gone to great lengths to try and to show that they could discredit this evidence, and the lengths that they've included have been some of the most bizarre and far-fetched notions I think I have ever heard. They've hinted that blood was planted. They've tried to create the impression that multiple other blood stains were contaminated and that somehow all the contamination only occurred where it would consistently prove the defendant was guilty. So now the little amplicons, the little DNA, they're co-conspirators too, because they know they've got to rush to only the places where you can attribute the blood to the murderer. When you think about that, just think about that one point logically, okay? Obviously, it's common sense. If contamination is going on, you're going to see it going on all over the place. As a matter of fact, if what they're saying is true with this aerosol effect, flying DNA all over the place, then Mr. Simpson's blood type ought to be showing up in other cases. Somewhere, somewhere out or down in another department in a rape case, Mr. Simpson's type should be showing up.
It's on my curtain right now.
Or even just to confine it to this case. Talk about that. How come, if the argument is
it's not
that his blood is flying all over the place, DNA is flying all over the place,
looks
why
like
didn't we find
the sound is
his
fine.
blood type showing up where it obviously shouldn't be? What I mean is this.
My green bars are flying all over the place. You guys can't hear it? I don't know why. It's... Oh, you're screwing with me. Right? I think you're screwing with me. I think I fell for it.
They took samples from the pool of blood by Nicole's body. They took samples of blood that was near Ron Goldman's body. Obviously, the blood came from them because they were lying there. And then, of course, you have the blood drops leading away from the crime scene. That had to be left by the killer. There's no question about that. That was left by the killer because they're next to the bloody shoe prints. So you know. Why is it that the sample of blood they took from her pool of blood didn't come up with the defendant's blood type? If the defendant's blood type DNA is flying all over the place, it's flying all over the place. Then it ought to be all over the place. Why isn't it in the pool of blood?
I don't see anything wrong. I see nothing. But it's not muted, Bren. It's just not. Hold on, I'm asking someone else to come in here and see if they can hear it. Yeah. All right.
sample that was taken from Nicole
It's
Brown?
playing right now.
Why isn't it
It's
in
playing.
the pool of the blood sample that was taken from near Ron Goldman's
I'm going
body?
to go back to
Logic,
the beginning.
common sense. It ought to be there. The DNA, the amplicons, those little things, they don't know
Martha,
where to
can you
go.
hear Marcia?
They're not guided. Contamination is a random thing. Happens willy-nilly. What
Willy-nilly.
you have here is they're trying to get you to believe.
Please be seated. And let the record reflect that we've been rejoined by all the members of our jury panel.
All right, it's playing right now.
Ladies and gentlemen,
Fine.
my apologies to you for those interruptions. And my
Can you
apologies
hear
to Ms.
it?
Clark for having interrupted her train of thought there. A couple of things happened that I needed to deal with immediately, and I apologize to you for the disruption in the thought process. We
You
will
can
go
hear it
through
fine,
at this
Martha?
point until 5
Bren,
o'clock,
refresh.
And then we'll take our mid-afternoon recess. And however, I realize that since we're having extended hours, one or two of
Refresh
you
and tell me if that
for a
helps.
break. So if you do, just raise your hand, get the bailiff's attention, and we'll take a quick 5 or 10 minute break if you need to during the longer hours. Ms. Clark.
Thank you, Marcia. Thank you.
Good afternoon. Okay. So now we've talked about conduct, we've talked about opportunity and timing. Let's talk about the physical evidence. I'm not going to do it in the detail you've already heard it, heaven forbid. But although you've already seen, with the opportunity evidence, with the conduct evidence, we already have evidence to show
YouTube
you
gets
that the
us
defendant
all.
did commit these murders, without even really getting into the physical evidence. And once you see the vast array of physical evidence, you can see that there's virtually an ocean of evidence to prove that this defendant committed these murders. What all of it does, all of this evidence, is it links the defendant to the victims and the crime scene at Bundy. Now, the defense has gone to great lengths to try and to show that they could discredit this evidence, and the lengths that they've included have been some of the most bizarre and far-fetched notions I think I have ever heard. They've hinted that blood was planted. They've tried to create the impression that multiple other blood stains were contaminated and that somehow all the contamination only occurred where it would consistently prove the defendant was guilty. So now the little amplicons, the little DNA, they're co-conspirators too, because they know they've got to rush to only the places where you can attribute the blood to the murderer. When you think about that, just think about that 1 point logically, okay? Obviously, it's common sense. If contamination is going on, you're going to see it going on all over the place. As a matter of fact, if what they're saying is true with this aerosol effect, flying DNA all over the place, then Mr. Simpson's blood type ought to be showing up in other cases. Somewhere out or down in another department in a rape case, Mr. Simpson's type should be showing up because it's everywhere. Or even just to confine it to this case. Talk about that. How come, if the argument is that his blood is flying all over the place, DNA is flying all over the place, why didn't we find his blood type showing up where it obviously shouldn't be? What I mean is this. They took samples from the pool of blood by Nicole's body. They took samples of blood that was near Ron Goldman's body. Obviously, the blood came from them because they were lying there. And then, of course, you know you have the blood drops leading away from the crime scene. That had to be left by the killer. There's no question about that. That was left by the killer because they're next to the bloody shoe prints. So you know. Why is it that the sample of blood they took from her pool of blood didn't come up with the defendant's blood type? If the defendant's blood type DNA is flying all over the place, it's flying all over the place. Then it ought to be all over the place. Why isn't it in the pool of blood sample that was taken from Nicole Brown? Why isn't it in the pool of the blood sample that was taken from near Ron Goldman's body? Logic, common sense. It ought to be there. The DNA, the amplicons, those little things, they don't know where to go. They're not guided. Contamination is a random thing. It happens willy-nilly. And what you have here is they're trying to get you to believe that only the killer's blood was contaminated, and it was consistently contaminated with only the defendant's blood type. Does this make any sense to you? What you ought to have, if you have contamination, if you've got a problem here, is that some of the blood drops come back to the defendant, and some don't. They come back to the real killer. That's what you ought to get, because it can't be this consistent. If you had one blood drop in this case, ladies and gentlemen, you know, you might be concerned with all of these possibilities they've raised, but you have so many. You have so many. You've got 5 blood drops leading away from the bodies of the victims out to the driveway, and you've got the blood on the rear gate. And that's the other part of their scenario that makes no sense. No sense. You have all these police officers that were there on June the 13th. Officer Risky saying his partner, a young rookie named Officer Terrazas, shined his light on the rear gate to show him the blood on the rear gate. You have Officer Risky seeing the blood on the rear gate. You have Officer Rossi seeing the blood on the rear gate. You have Detective Phillips seeing the blood on the rear gate. All of it early on. Dennis Fung, whom you can see, is not the model of efficiency, forgot to collect it. And from this we get a theory that they seem to imply that the blood was planted. Why do they say that? Now, first of all, I want to hear Mr. Cochran actually stand up in front of you and tell you he believes the blood was planted. I want to hear that, because that is incredible. That is absolutely incredible. When you think about that, think, what evidence have you been given to show you how? that blood was planted, to show you when that blood was planted, to show you who planted that blood. Now, the reason that they have to come up with this story about contamination and planting, and I want to hear if they really, really do that, say that to you, is because they can't get around the result. You recall Dr. Gerdes testified for the defense, and he said that the DNA testing that allowed for RFLP, the most powerful of the techniques of DNA, was successful on the rear gate because that blood had higher molecular weight DNA. From the fact that you have higher molecular weight DNA on blood collected later, July 3rd, they want you to infer that somehow it was planted. But they're inconsistent because if you remember, now if you plant the blood, aren't you going to plant it close to the time you collect it? What are you going to do? Plant it and hope somebody finds it later? You plant it when you expect someone to find it, right? When they have the EDTA going on, you have all these cross-examination questions about EDTA breaking down due to sunlight exposure. There's no proof that that happens, by the way, as you could tell. And they did no test to prove that that happens, by the way. Would be nice. If they want to prove that, do a little testing. You've got the expert right there. Why didn't he do any tests, by the way? But he didn't do any, okay? So they're asking him about EDTA breaking down in the sunlight, trying to infer that it was there for 3 weeks, that the blood was there. If it's there for 3 weeks, it wasn't planted, folks. It was there on the night of the murder. This is what I mean by inconsistent, illogical. This makes no sense. If you're going to say that the blood was planted, then you're going to say that it was planted at or near the time of collection, in which case the EDTA would not break down, in which case the EDTA should be intact, in which case you should see the kind of high, smooth arc that the graphs showed you from the reference tubes, instead of the jagged noise that you actually saw. And they brought in Dr. Readers to try and tell you that that jagged noise looks just like that high arc, which is ridiculous, which is insulting to your intelligence. But the reason that they have to say this, defying logic, defying common sense, is because, ladies and gentlemen, his blood on the rear gate, with that match that makes him 1 in 57 billion people that could have left that blood. I mean, there's 5 billion people on the planet? That means you'd have to go through 57 billion people to find the DNA profile that matches Mr. Simpson's. There's only 5 billion people on the planet. Ladies and gentlemen, that's an identification, okay? That proves it's his blood. Nobody else is on the planet. No one. Now, they know that. Now, the blood on the socks, Nicole's blood on the socks. Again, RFLP match, very powerful. Showed from cell mark, that was a 5-probe match, I believe, found to be 1 in 6.8 billion people. Again, more than there are people on the planet, identification. An 11-probe match by DOJ showed that it was 1 in 7.7 billion people. Again, her blood and only hers on this planet could be on that sock. Now, how do you get around that? It wasn't wrong, and they couldn't find an expert who would say it was contaminated because there's too much DNA. That is the blood. That type is the type. It is her blood. How do you get around that? And if you know that that's true, if you know it's her blood on his socks that they find on the morning of June the 13th, that alone, with a rear gate stain, convicts him. You can't believe otherwise.
It does.
There's so much proof now. How do they get around that? They have to find a theory to get around that. And what do?
Okay. So she's doing great. She's right. She's saying the words that she should have said the whole trial. Her blood is on his socks in his house. They're divorced. They don't live together. It's not like she accidentally cut herself chopping a salad earlier and the blood got on his sock. Her blood is on his socks that are laying out in his house. Oh, I get it now. I get it. It's so hard because it's unnatural for his socks to be laying out in his room. That is unnatural. His room is perfectly clean. Why would he put 2 socks on the floor? So Furman planted the socks. I get it. Okay. This is so frustrating to hear and watch. It's just so frustrating.
This is what they come up with. So if it's low in volume DNA, it's contaminated. If it's high volume DNA, it's planted, and it's also very convenient and ridiculous. Now, their experts had access to all of the evidence in this case. Their experts could have come in and shown you how the evidence got contaminated. Not possibly. Remember I talked to you about mere possibility? No, did get contaminated. And they could have come in here and told you and pointed out the evidence that showed why only the blood drops left by the murderer got contaminated, and shown you why they consistently and only got contaminated in a way that showed the defendant's DNA type. Not that they possibly could have. Yes, possibly we're all sitting on Mars right now, and I'm from Venus and I'm talking, anything's possible. Let's talk about what did happen. Let's talk about what we've got. They could have shown you proof that the Bundy blood drops were contaminated, not the mere possibility. No, I'm talking about evidence that gives you a reason to conclude that that happened, and that they never could do. And they could have done it if it were true, but they didn't. And not one expert they brought in on the DNA did even one test on the blood evidence, the evidence that we have that proves to you that the defendant committed these murders. Not one. With all those experts you saw. And the reason for that, ladies and gentlemen, is that it isn't true. The blood on the Bundy trail comes back to the defendant because it's his blood. The blood on the rear gate comes back to the defendant because it's blood he left there on the night of the murders. So they took you through all this tortured and twisted road, one moment saying that the police are all a bunch of bumbling idiots, the next moment they're clever conspirators. And now ask yourself, did they ever prove who planted, when, how? And it's a fact that the defense doesn't have to prove anything. That's a fact. But once they do decide to put on a case, once they decide to try and prove something, their witnesses are subject to the same scrutiny as the people's witnesses are. Your jury instruction, as I've told you, makes no distinction. It's up to them to do the best job that they can to make their point. And I think a good example of how they failed to do that miserably in this case is the EDTA, that preservative that you find in the purple top tube. They've got to make you believe that blood was planted. It's the cornerstone of their defense. It really is, because as I've pointed out, if you know that's his blood left on the rear gate, if you know that's her blood on his socks, what are you left to conclude? Now, what do they do to show you, to prove to you the cornerstone of their defense? What do? They take our tests, and they have some other expert who neither did the test himself nor could come in and try and interpret those graphs for you. Not only that, but he does it inconsistently. He writes a report, if you recall, he wrote a report in which he said he found one parent ion and one daughter ion, not the full daughter spectrum that would permit identification of EDTA, but the same finding of one parent ion, one daughter ion that Mr. Martz said he found in his own blood, in his own unpreserved blood, which does prove that the blood on the rear gate, the blood on the socks, are just like Agent Martz's unpreserved blood, natural blood, not from a preservative tube. So what did they do with that? Here's what happened. Dr. Reeders wrote that report, and he said the blood on the sock, the blood on the gate, one parent ion, one daughter ion. Wrote that report, I believe, on July 17th. A few days after he wrote the report, he found out that Agent Martz had just done the test on his own blood and come up with the same result he got on the sock and the gate. Very, very low noise readings, and only 2 of the 3 ions he should have found, which leads you to understand that it was unpreserved blood. Well, now he's got to do something about that. He has to answer that contradiction, because now what we've got is he can't address this. We have proven conclusively it was not EDTA blood. He's got to do something to make his testimony weave its way around. So he gets up and on the stand for the very first time on this witness stand. He makes a new conclusion, and now he says, I find a peak that shows the second daughter ion on the sock. Dr. Reeders, what happened between the time of your report and your testimony? Did you do some tests? No. Did you do some experiments? No. Were there some new graphs? Yes. Agent Martz's blood. Not new graphs on the sock. Agent Martz's blood. He had to change his testimony to encompass evidence that refuted his conclusion completely. But what they gave you is somebody who did not one test. With access to all the evidence, he tested nothing. They have the experts to do the test. They did nothing. They have the experts to do experiments to prove things they want to prove about it. Nothing. That's the cornerstone of their defense, ladies and gentlemen. They did nothing. Now, what does that tell you? What that tells you is they know this is not EDTA blood. Saying it's so doesn't make it so. Having a lawyer stand up in front of you and say something, no matter how often it's said, doesn't mean it's true. I include myself in this. You know, I only argue what the facts show, what I believe the facts have shown, and any reasonable inferences that you can draw from them. That is all. I cannot stand before you and tell you something that is false, that is untrue. You need to go with what is true, with the evidence, with what we have, and the reasonable, common sense deductions that you make from that evidence. I don't ask you to take my word for anything. That's why we present on evidence. That's why we call witnesses. If it isn't in the record, or it doesn't make sense to you as a logical inference from what you've heard, reject it. I don't care who says it, reject it. But do the same for the defense. Hold me to that standard, hold them to that standard. When you hear them try to tell you that all of this evidence was either contaminated or planted, ask yourself, does this really make sense? What evidence was I given to prove that? Is there any evidence that really shows that? Or is it smoke and mirrors? Is it all the smoke to cloud everything, cloud all the issues, distract you? Take a little piece here, take a little piece there. Kind of reminds me of that story about all these guys that are blindfolded, and each one goes to a different end of an elephant. One grabs the tail, and he says, feels like a rope. And the other guy grabs the trunk, and he says, feels like a fire hose. And another guy grabs the leg and said, feels like a tree. Okay? Not one of them got it right, did they? Take off the blindfold, it's an elephant. You put all the pieces together, you put the whole picture together, and you can see the truth. But what they have done systematically is fragmented the case. Now, this is not new. I mean, they did a very good job of it. They're fine lawyers. And they challenge the people's case as they should, and that's good. You put the state to their proof. That's what we have to do. We have to deliver. That's our job. And we have. But be aware of what's happening here. They're fragmenting. They take little pieces out of context and focus on only that little piece. And take a little piece of a picture, focus on only this little piece of the picture, and forget about all the rest. It puts it all in context. Give Henry Lee second-generation photographs that you can't see anything on, instead of the good stuff, the original photographs that would show him what's going on Bundy Walk there. Now, back to DNA. I'm sorry, I digress. Even when it's analyzed using the PCR method, it's not quite so easily contaminated as the defense would have you believe. As you've learned, it's used every day to save lives. And as you've also heard, it's used in very non-sterile conditions. It's used to identify war dead. Now, what does that mean? War dead, soldiers who die in jungles and in deserts. Those are not sterile environments, ladies and gentlemen. Those are very dirty environments. But they use PCR testing to identify those soldiers. And why do they do that? So they can notify next of kin. That's a very serious responsibility. You better be right. You better be right. Now, if it's good enough to go and notify next of kin that their son, their daughter, their husband, their father has been murdered or killed, on a battlefield, then it better be good and reliable stuff. So if it's good enough for that, on body parts being recovered from jungles and deserts, it's pretty hardy, pretty durable. Now, Dr. Lee, the defense expert, they gave none of the DNA evidence to examine, who is a forensic expert, approves of DNA testing in criminal cases. Notice they didn't ask him to look at the evidence here. Notice they didn't ask him to tell what he thought of the results in this case. A forensic expert, a criminal expert. They didn't ask him. Who'd they bring in? Dr. Gerdes. Dr. Gerdes, who has admittedly no experience in forensic cases, came in to tell us about validation studies and dot blots. But what did he do in this case? What forensic criminal experience does he have? Zip. None. Why do you even use a guy like that in a criminal case when you've got Dr. Lee? And don't forget Dr. Blake. Dr. Blake, who is renowned as a scientist, who is one of the foremost experts and leading ones in the forensic use of PCR technology, whom they had watching the testing at DOJ, examined the evidence in this case, took cuttings of the evidence in this case
Hi,
at Selmar,
Richard. Hi,
never
Walter.
sat in that blue chair for the defense. Why not? Where was he? If you have evidence to prove that there is something, that there is contamination in these samples, you have an expert who is there watching the testing, who is an expert in the field of PCR, does it in criminal cases all the time, he's renowned, you never call him. What sense does that make? What does that tell you about what you've been given here in the nature of the defense? Smoke and mirrors, ladies and gentlemen. And by the way, when DNA degrades, as you've been told, it doesn't turn into someone else's type. You get no result. And you may remember, no result. I mean, degrades, nothing. You may remember that Dr. Cotton testified. She was asked, well, how would a swatch in which DNA is all degraded get contaminated with another person's type? How could that happen? She said, well, really, they've got to be touching. The swatches would have to come in contact. A swatch of somebody else's type would have to come into physical contact with a swatch where the DNA had completely degraded. She could not envision flying DNA, as they have tried to sell you in the defense, because DNA just doesn't jump or fly. And don't forget, in case you had, we even did prove that their contamination theory was untrue. If you remember, we had a lot of testimony, what we called substrate controls. Now, all the substrate controls are, it's really, I think you'll remember, it's very simple. You go and you collect a blood stain from here, and then, in order to make sure that the blood type you're going to pick up there isn't the result of something underneath that was already there before the blood came down, you take a little swatch right next to it to show that the ground underneath didn't have any DNA. And we did that. That was done at Bundy, next to every blood stain, systematically done. Now, how do they help you? When you go to test the swatches, The bloodstain swatches and the controls are tested the same way. And if you have contamination, the controls should come up showing DNA. And the controls on the Bundy walk did not. And there you go.
You can rest now. And there you go was a perfect mic drop. Now walk away.
Oh, I wanted to go over
Never
an
mind.
instruction with you. This is a long instruction that has particular relevance to this case.
Of course it's a long instruction. Of course it is. Jurors are going to hate her. Look at all those words on that board.
It's called, this is the instruction about circumstantial and direct evidence.
That's ridiculous.
There's a lot
That
of
is
words in this instruction, I must say.
ridiculous.
Let me first say something to you about direct and circumstantial evidence. This instruction explains them both. I don't know how well. I'm not a big fan of these, the way they're written. I think they could be a lot clearer, frankly. But they talk about direct and circumstantial evidence. This one is just circumstantial evidence. You have another instruction that distinguishes between the two. You're told in these instructions that direct and circumstantial evidence are of equal weight. Neither one is better than the other. Now, an example of direct evidence would be an eyewitness, someone who would say, I saw him, I saw that. We have an eyewitness in Allen Park, okay? His testimony seeing the man we know to be the defendant walking into the house at Rockingham. Allen Park testified to his observations. That's direct evidence, okay? Circumstantial evidence is evidence that leads you to infer, okay? For example, in this case, the blood. The blood at Bundy dripped by the killer next to the bloody shoe prints. It's not direct. Somebody didn't see the murder being committed, didn't see the murderer leaving the scene of the crime, but you have the blood of the murderer left behind. It's kind of like, and you have the blood on the rear gate. That actually identifies Mr. Simpson. That's kind of like a fingerprint, okay? That's circumstantial evidence, as opposed to seeing it. Now, in terms of quality, there's no difference. The law has no favorites. But when you think about it logically, circumstantial evidence has a lot of benefits that direct evidence doesn't. What is that? It gives you a lot of quality assurance. It gives you independent corroborating bases on which to believe that the defendant is guilty. Instead of relying on one person's observation, one person who might be mistaken, who might be tired, who might not have observed very well. You know what happens because you saw it happen in this case. What happens with an eyewitness? They start out saying, for example, a robbery, okay? I was standing on the street corner and I saw the defendant go over to the woman and grab her purse. Okay, purse snatch. Okay, cross-examination. How far away were you from that woman? Where were you standing? Were they standing in shadow? Do you wear glasses? How much of the defendant's face did you see? Half? 3/4? Only a quarter? What kind of hair did he have? What kind of shirt did he wear? What kind of pants did he wear? What color eyes did he have? Did he have a goatee? Did he have a mustache? Did he have a beard? And so on and so forth. And the witness starts to get torn down. And if that's all you've got is that person's observation, it'll make you a little unsteady about whether or not you really have enough proof to give you that certainty that you need. Now, contrast that with the following. You have the defendant committing a purse snatch. And what you have is someone who hears the woman scream, sees the back of a man running, and then a few minutes later, the defendant is caught 3 blocks away holding her purse. Assume for a moment that she cannot really identify her attacker. You got him with her purse just a few minutes later. A lot of things can be said about how it got to him, but that's circumstantial evidence. But even that circumstantial evidence is not nearly as good. It doesn't come close to what we have in this case. In this case, you have circumstantial evidence of the blood, you have hair and fiber, and you have some of the conduct evidence and the opportunity evidence. You have a wealth of evidence in this case, all pointing to one person, the defendant. Now, this instruction, usually when I see lawyers argue this, they take out one paragraph and they only talk about that one. I'm going to talk about the whole instruction here. Okay, begins in the very first paragraph with the fact, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. You'll see the word reasonable, rational throughout these jury instructions, because that's what it's all about. Reason, common sense, logical, rational. All right, now I'm going to jump around between this, and I'm going to come back and forth to this instruction because there's a lot here. But in the third paragraph, this is what I told you about a little bit earlier.
RW, I feel that.
Reasonable interpretations. Remember I gave you the example of the Bronco that could have been on Ashford or could have been gone completely at the time that Charles Cale was walking his dog. You had two reasonable interpretations from that evidence when he said he couldn't see the Bronco on Rockingham. At the point in time that he testified, based on his testimony, you had two reasonable conclusions to draw. Either that it was not there at all or that it was on Ashford and he didn't see it. When you have two reasonable interpretations, one of which points to guilt and the other to innocence, you adopt the interpretation that points to the innocence and reject that interpretation which points to his guilt. That is when they are equally susceptible of two reasonable interpretations. If, on the other hand, one interpretation of the evidence appears to you to be reasonable and the other to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Reasonable, rational. The defense will argue to you many things, inferences that could be drawn, just like the possibilities I talked to you about. Ask yourself, are they reasonable? Because if they are not, if those inferences are not reasonable, then you are to reject them and accept the reasonable. And that's why I keep referring to common sense, rational, logical. All right, I'd like to start with hair and fiber. If you remember, Mr. Diedrich testified about the microscopic comparisons of hair and fiber in this case. And when he did so, well, first, let me point something out. His testimony was uncontradicted by any other expert. His testimony is not disputed. His conclusions are not disputed. And you know that the hair and fiber evidence was examined by at least two other experts for the defense. Now, when Mr. Diedrich testified, he told you what his conclusions were based solely on what he could see through the microscope. That's all he could tell you about. He did not take into account the results of the DNA testing. He didn't take into account the testimony of Cato or of Alan Park. None of that. He looks through a microscope. So all he can tell you is that the defendant's hair shares the same microscopic characteristics as, for example, the hair in the knit cap found at Bundy, or the hair found on Ron Goldman's shirt. He can only say it's consistent, shares the same microscopic characteristics. But when you take into account all of the evidence, including the DNA, including the testimony of Cato and Park, including the defendant's opportunity to commit the murders, including his post-homicidal conduct, you know it's his hair. You know it's that fiber. So now we are going to put it all together. So when I talk to you now about the defendant's hair in the cap, I'm talking about not just Doug Diedrich's testimony. I'm talking about his testimony along with everything else, all the reasonable inferences that you can draw, all the logical conclusions that you come to, knowing all that we know in this case. Now, I'm not going to talk about every conclusion that Mr. Diedrich testified to. Some of them were only testified to give you more information, more background, more knowledge about what you expect to find in this testimony. So let's start. What I'd like to do is start with the bodies at Bundy and move away from them as the defendant moved away from them after the murders and analyze all of the evidence that was left behind from that perspective. And just so you know, I will show you a couple of photographs from the crime scene, but I'm not going to put up any coroner's pictures. I've seen enough of that for a while. So when I describe the wounds from the coroner and that sort of thing, I'm just going to describe them. You're not going to see pictures from me. You can see them back in the jury room if you like. All right, let's start with the knit cap. Can we get the Bundy board? With the knit cap, I think we have to cut the feed. Thank you.
I think I remember once, but I don't know when it was, that we were off school because it was too cold. Once in my life.
Again, this is an argument board. You're not going to get it back in the jury room. This is just for me to talk to you and show you stuff with. It's too low. Raise it up a little.
I believe you. I believe that was it. Because I wasn't in like grade school. I was in high school, so you're right. It would have been 1994-ish.
All right, 2:30. Can you see it now?
All right, the knit cap. You can barely see it under the plant here. This is the position in which it was found. Now you can see how the defendant could miss it in the dark. It's underneath that plant. I'm pointing to it right here, that blue, patch of blue here. On that knit cap, you recall that well, it's the defendant's hairs. Now, let me refer specifically to Mr. Diedrich's testimony in this regard, because what he told us is this. He said there were the hairs that he said were consistent with the defendant's. He found 9 inside the cap. And it's clear, extrapolating from his testimony, it's clear that they were 9, I think, naturally shed hairs, is what he said. Not fragments, but naturally shed hairs. That he wore the cap from that. Now, what's interesting also is that he talked about fragments that were found inside the cap, hairs of black origin that were not consistent with Mr. Simpson's. And so I asked him, you know, what about those hairs? Well, he said they were treated, chemically treated. How long were they in the cap? Can't tell. They could have been there for years. Because you can, you know, life experience, if you ever had anything knit like that, kind of a loose weave, and you'll have it in evidence, you can check it out, it's going to get hairs in it, and those hairs could stay there for a very long time if it's not washed, it's not laundered. So that's why I asked the defendant's hairdresser, could it have, what about the defendant's former wife, Marguerite? Did she treat her hair? What about Arnell? Did she treat her hair? These are other possible people that could have worn the cap and whose hair could, the fragments, old fragments, could be from. But the 9 naturally shed hairs inside the cap that were consistent with the defendant's were different in quality than those because they were not fragments and therefore unlikely to be old. All right, and taking into account everything that we know, those were his hairs in the cap. He wore the cap. He also found on that cap fiber, and he said it was consistent with the carpet from the defendant's Bronco. And he talked to you about the unusual nature of the trilobal cross-section of that fiber, and he showed you photographs of it that were taken from the scanning electron microscope. You'll have that back in the jury room if you want to see it. It's very interesting stuff. But what we know, from all we know, that was a fiber from the defendant's Bronco on that cap. Now that's very important because that actually, with that cap, we have tied the defendant and his car to the crime scene at Bundy. And now you see, to summarize, on the knit cap we have the defendant's hair and the Bronco fiber from the carpet in his Bronco. And another piece of the puzzle. Now let's go to Ron's shirt. Now on Mr. Goldman's shirt, we have the defendant's hair and we have the blue-black cotton fiber. Now, of course, the defendant's hair is of obvious significance. Mr. Diedrich was asked whether or not that hair appeared to be the hair that he said was consistent with the defendant's, whether it appeared soiled. He said no. That was very important, and that was very important for this reason. If we had simply found hairs of the defendant in the soil of that area in Bundy where Ron Goldman was lying, we probably would not think that was a big deal. Why? He visited the place. He was there, pick up the children, leave the children, and that there might be stray hairs lying around in the soil, you know, falling from whatever reason. This would not be very significant. I wouldn't be standing here talking to you about it right now. But you have an unsoiled hair on the victim's shirt. That's important. And that makes the distinction. Because if it had been something he picked up from the soil, then you should have seen dirt in it. The fact that it was unsoiled means it was the result of contact between the defendant and Ronald Goldman that night during the murders. We certainly have no reason at all to believe there was any contact between the defendant and Ronald Goldman before the murders committed. We have something else on Ron's shirt. We have the blue-black cotton fibers. All right, so what's the big deal about that? Well, you recall that Mr. Diedrich found blue-black cotton fibers in 2 other places. And the blue-black cotton fibers that he found that shared the same microscopic characteristics as those he found on Ron Goldman's shirt were found on the Rockingham glove and on the defendant's socks. So what could that be? Well, clearly, those are fibers from what the defendant was wearing that night. You recall what Cato described. He was wearing the dark blue to black cotton sweatsuit with long sleeves. Now, a sweatsuit has banded ankles and is going to be in contact with your socks. Obviously, too, a sweatsuit, you know, if you have an elastic ankle, exertion, you're going to pull the pants up. It's going to rub. There's going to be some friction there. And it's natural, of course, it's also common sense, that you will find fiber from one piece of clothing transferred to another, which is why, if you recall, when he was testifying, I asked him, did you find any of Ron Goldman's shirt fibers on his jeans? Yeah, I did. Not a surprising thing, very common. Same thing happened with the defendant. And when he had contact with Ronald Goldman, when he attacked Ronald Goldman, he left fibers from what he was wearing on Ron Goldman's shirt. And when he went to take, and in wearing that sweatsuit over those socks, he left fibers on those socks. And in having maybe the Rockingham glove in his pocket, when he was running down the south pathway, picking up fibers from it, from his clothing, when the glove fell out, it still had the fiber from his clothing. And that's why you have those fibers sharing the same microscopic characteristics with all the tests he performed on them, there were quite a few, in those three places, going to the crime scene, the south pathway, and the defendant's bedroom. So with this piece of evidence, we've tied the defendant to the murders, and this link carries us from Bundy clear into the defendant's bedroom in Rockingham. And here's a summary of what we've just discussed: the defendant's hair on Ron Goldman's shirt and blue-black cotton fibers. Yeah. And another piece of the puzzle. All right, now let's move away from Ron and start up the walkway. Now, I'm going to direct your attention to the board. The bloody shoe prints. Now, the bloody shoe prints actually start down here. I'll just hold it up for a minute. On this very first photograph on the bottom, you can see the shoe print right next to the blue knit cap. It starts between, okay. And those bloody shoe prints go all the way down the walkway till you get to about halfway when they fade out. This is another important piece of evidence that proves the defendant's guilt. The shoe prints are all size 12. The shoe prints were all, and by the way, size 12, less than 10% of the male population wears that size. And the men who wear that size tend to fall within the height range of 5'11" to 6'4". The defendant is 6'2". And these are not just any size 12s. They're expensive shoes. Casual shoes that cost $160. Not dress shoes. Shoes that would be worn by a rich man. The kind of man who would wear cashmere-lined gloves. And what's even more important is that those shoes were only sold in 40 stores in this country. Out of how many thousands, maybe even millions of stores in this country, these shoes are only sold in 40 of them. And one of those 40 stores was Bloomingdale's, the store the defendant shopped in regularly, where he would buy shoes, both dress and casual, as you heard the testimony. They stopped selling those shoes back in 1992. But during the time that they sold them, the defendant was shopping at Bloomingdale's. Now, as we move down the walkway, we see that there's only one set of bloody shoe prints. Mr. Boziak, I think, made that very clear, especially on his last visit. Only one set of the imprints were bloody shoe prints. And all of them were consistently Bruno Magli, size 12. And there's the summary. Defendant's shoe size is 12, less than 10% of the population. Expensive, rare men's shoes sold at very few stores. And another piece of the puzzle. Now we look to the left of the bloody shoe prints, and we see the blood drops on the walkway. These are the blood drops left by the murderer. I've already talked to you about that, and it's clear because they go all the way alongside to the left of the bloody shoe prints down that walkway. 5 blood drops, all of which match the defendant. Now, of the 4 inside the gate, 4 on the walkway that is inside the gate, all 4 were done with PCR. 1 was also done with conventional serology.
Hey guys, I have to leave early today because of the snow and the roads and everything, so it's going to take me a little longer to get her to work and home again. So I'm leaving right now. I'll be back as soon as I can. It just might take me a tiny bit longer today because of the snow. Not a lot. Pennsylvania is really good with snow, so we'll be okay. But behave.
You recall there was testimony about that from Greg Matheson, but all of them match the defendant. As we get to the rear gate, we see that there's more blood. And this blood also matches the defendant. Now, on the rear gate, I think I've already talked to you about that. The blood that matches the defendant was typed to 1 in 57 billion. In other words, that's identity. That is his blood. And then we go out to the driveway, and you recall blood drop number 52. And that drop was also done with RFLP. And in that blood drop out on the driveway, you have the typing, I think, determined with RFLP was that it was 1 in 170 million. The reason for the lower number is because they had fewer probes. It was a weaker sample. The reason for that, I'll talk about that for a minute. You have a different environment. And I think it's important to note, on the walkway, we don't have a good picture of it here. There are other pictures that you have in evidence that'll show this. The walkway is very dirty, and it's concrete. It's porous. It absorbs. On the other hand, on the gate, you have a smooth surface. It's up off the ground, and it's not as much in contact with dirt and with the elements, and it's not going to be absorbed in the gate because you have the paint on the gate that prevents it from doing that, which is why you have higher molecular weight DNA. The more that DNA is subjected to bacteria, to dirt that degrades it, the more it's going to degrade, the less DNA you're going to have. The dirtier the environment, the less the DNA. The cleaner, less hostile environment, the more DNA. Very simple. So you have more DNA on the gate than you do on a dirty walkway. The gate is not the cleanest thing in the world, I guarantee, but you do have, it's up off the ground. You do have a non-absorbent surface. So that's part of the reason for the higher weight DNA. The other part of the reason is that the rear gate, by inference from all of the testimony, that stain was collected and taken down right away instead of sitting in plastic bags in a hot truck. All right. So you have all of the blood on the walkway matching the defendant. You have RFLP results on the rear gate that identifies the defendant. You have a drop on the driveway, 1 in 170 million. That's a virtual identification of the defendant under all of these circumstances as well. And another piece of the puzzle. Now let's talk about the Bronco.
All right, Mr. Escobar, would you just show that briefly to counsel, please? All right, thank you.
All right, first of all, just consider the fact that there's blood in the Bronco at all. I mean, ladies and gentlemen, do you have blood on the interior driver's door of your car, on the dashboard, on the console? I mean, think about that. And all at the same time? As for the amount of blood in the car, how much would you expect to see? When you think about it, the defendant inflicted the wounds that bled out on these victims, the ones that really bled out, from behind them, to the throat cut that was demonstrated to you by Dr. Lakshmanan. So if he's standing behind them, they're bleeding out this way, how much blood is he going to get on them? Not very much. And he certainly wouldn't be getting any on his back, which is where he's going to be in contact with the seat. It's his back and the back of his legs. No. If any blood at all, on his hands, from touching. So the blood that you see in the Bronco is actually, logically speaking, where you'd expect to see it from a cut hand or from a bloody glove that's dropped down next to the console. It's the amount you'd expect to see, it's where you'd expect to see it, given the circumstances of this case. Now let's talk about the cut finger. Look at where we found blood on the door. You found blood inside the well of the driver's door handle, and you found some closer to the driver's window. This blood in here, in the well of the driver's door handle inside the car, how do you get that blood there? Think about where you'd have to put your hand. Think about where you'd have to be sitting when you put your hand there. When you get out of the car, if you're seated in the car, in the driver's seat, and you need to open the door to get out, that's what you do. You put your hand in the door handle to open it in a seated position. So that blood got on there after when he drove back from Bundy with a bloody finger to get out of his car. That's the only position you could be in, to get the blood in the well of that door handle like that. Because to get it there, you're opening the door. And to be opening the door from inside the car, you'd be seated in the car. So now we know yet another fact that shows that he was bleeding in that car long before he went out to get his cell phone from the Bronco to leave for the airport. Now, the defense is not claiming that the defendant's blood in the Bronco was either planted or contaminated. They concede that one right up front. And that's because they can come up with an explanation for that one. Remember the razor-sharp cell phone. But remember, it's only the evidence that they can't otherwise explain that they resort to the desperation theories of contamination and planting. But it's not only the defendant's blood in this car. There's also the blood of Ron and Nicole in that Bronco. And there are other people who saw that there was blood in that car at Rockingham in the early morning hours of June the 13th. Recall another witness called by the defense, Officer Don Thompson, who was guarding the car and kind of taking care of business at Rockingham. He saw the blood in the Bronco as well. Now, you may remember that the blood on the console was initially collected. By the console, I mean the area here marked by the number 31. This number tag is in between the seats. Testimony was that Dennis Fung collected blood from that console on June the 14th at the print shed. That was before it went to Vertel's, that tow yard where it seems that everybody and his brother went to look at that car. Before it went there, Dennis Fung collected that blood. Now, the results of the blood collected by Dennis Fung in the morning of June the 14th indicated with PCR testing the presence of blood from the defendant and from Ronald Goldman. And it indicated that the response it was mostly the defendant's blood in that mixture. Now, you heard all the testimony about the insecure conditions at Vertel's and how the car was kept unlocked because they didn't have a key for it. And you may remember that the Bronco had to be towed from Rockingham because early in the morning when the police had contacted the defendant, if you may recall, Cato testified that the detectives asked him for a key to the Bronco because it was locked, they couldn't get inside it, and he couldn't find a key. And you may also recall that there was testimony indicating that the car had to be towed because it couldn't be unlocked. They didn't unlock it until the 14th when they had to do that with a Slim Jim. Basically had to break into it. Well, after the Bronco left Vertel's, I think it was about a month later, it went to a more secure location, and at the request of the defense, an examination of the Bronco was conducted in their presence. And Michelle Kessler told you of how she saw that Dennis Fung had not collected all of the blood off the console. And she said, let's collect the rest of it. So they took the console out, and Greg Matheson actually swatched the remaining blood off the console in the presence of the defense experts. And that was on, I believe, August 26th, either August 26th or September 1st. Now, that blood that he swatched on either August 26th or September 1st, in the presence of the defense, did not go through LAPD testing at all. That blood went straight up to the Department of Justice for testing. And it came back with an RFLP match that you heard late in the trial. RFLP meaning we had more DNA in it. And we were able to match the blood, again, to the defendant and Ron Goldman. That's very important for two reasons. Number one, it shows you that it is not so easy to contaminate DNA. It's not so easy to contaminate blood. Even though that console sat there in the Bronco at Vertel's, where everybody had to go and check this Bronco out, the results that were obtained on the morning of the 14th before it went to Vertel's are the same as the results that were obtained about 2 months later, 2.5 months later. So it tells you also that PCR testing is accurate. But of course, even more importantly, it tells you that Ron Goldman's blood is in that Bronco. And there's no reason for his blood to be in that Bronco, an RFLP match, unless the defendant committed the murders and had the blood of Ron Goldman on him to swipe on that Bronco. Now, there's something else about that Bronco that I wanted to point out to you. Can we take a photo? For this, I think it's better to show you the picture up on the screen. This, which one's this, John? 145?
All right, this is the photo of the Bronco driver's side
Yes, John.
floorboard. All right, Ms. Clark, proceed, and we'll have Mr. Farrell tell us which one this is.
We're going to try and help the resolution here a little bit. I showed you a photograph of this during the trial that I think was a lot clearer than what you're seeing now. This one's very faded. So we're going to get a clearer picture for you. What I'm going to point out to you, though, ladies and gentlemen, is the bloody imprint that was in the on the driver's side of that carpet. On the driver's side of the floor mat, where a driver would put his foot, we find a bloody imprint. A bloody imprint that Mr. Boziak told you had characteristics consistent with the Bruno Magli shoe of that S pattern that he talked about, and a bloody imprint that was tested and matched to the blood of Nicole Brown. That carpet piece was cut out of the Bronco by Dennis Fung on June the 14th at the print shed. Now, think about this one for a minute, because just the fact of having blood in that location tells you something. How in the world do you get blood on the floor mat in a position where a driver puts his foot unless you have stepped in blood and then sat in the car and put your foot on that spot? How else? How else? How many times have you stepped in blood, and how many times have you tracked it into your car? I don't know how many, but you could see just logically somebody who is walking around with bloody shoes gets in to drive his car, and the carpet comes up. There you go. And this is People's?
It's on People's 172.
People's 172. Thanks.
Thank you.
I'm going to ask Jonathan to point it to you. It's, you can probably see it though.
Go ahead and use the laser.
Oh, great. This is easier. Look. See right here? And that's what we had testimony about with respect to the blood testing and with respect to Mr. Boziak. But when I sat and I listened to that, I thought, gee, I don't know how much clearer it could be. I really don't. You have the bloody shoe prints going down the walkway, understandably on concrete, a hard surface, they fade out. Then you put that same bloody shoe that obviously got blood up in the grooves of the pattern of the shoe onto a soft surface like a carpet that picks up that blood, whatever's remaining. How else did it get there? And those bloody shoe prints that lead away from the bodies of Ron and Nicole reach right into the defendant's Bronco. All right, you can already see we have such a wealth of evidence that we could probably stop right here, but frankly, I'd like to, but I have to finish going through all of the evidence, and the Bronco went back to Rockingham. So let's go back to Rockingham as we trace the steps. And I'll quickly review the evidence for you at Rockingham.
Thank you, Jessica.
All right. So he gets in the Bronco and he drives back to Rockingham, parking it on Rockingham, just north of the Rockingham gate, where we see it in all of the photographs. Now, as I've described earlier, the defendant runs down the south pathway, and you're thinking to yourself, you know, why? Why would he do that? And I talked to you about disposing of the knife. Really common. Murderers want to get rid of the murder weapon. They think that's the one thing that can nail them. He's running back to that rear lot. He never gets there because he crashes into the air conditioner, dropping the glove. Why would he need to put the knife on his own property? You're thinking, why not drop it in a dumpster on the way home? Doesn't that make sense? Why not? Why would you want to do that? Leave it on your own property or bury it on your own property. He can't. He can't because he's famous. If someone sees him hanging around near a dumpster on that night of all nights, at that time of all times, dropping something into a dumpster, they're going to recognize him. And he's going to have a witness. A witness who's going to put him very close to the scene of the crime at the very wrongest time he could be there, right after the murders. He can't dispose of evidence in public. Every move he makes is noticed. So he's got to find a private place, and that's the one that makes the most sense. And he doesn't have a whole lot of time to get real creative here. So what do we find on the Rockingham glove, the one he dropped? We find everything. Everything. We find fibers consistent with Ron Goldman's shirt. We find the hair of Ron. We find the hair of Nicole. We find the blood of Ron Goldman. We find the blood of Nicole Brown. And we find the blood of the defendant. And we find Bronco fiber from the defendant's Bronco. We find blue-black cotton fibers just like those found on the shirt of Ron Goldman and on the socks of the defendant in his bedroom. And on this glove, he is tied to every aspect of the murder. To Ron Goldman, to Nicole Brown, to the car. And of course, that's why the defense has to say that the glove is planted. Because if they don't, everything about this glove convicts the defendant. Where it's found, what's found on it, what's found in it, even a black limb hair found inside the glove. Everything about it convicts him. Even though the planting theory is ridiculous, when you think about it, you give it a little rational thought and you realize it's absurd. Whatever you think of Mark Furman, nobody thinks much of him. He couldn't have done this. Why couldn't he have done this? It's not just the fact that all the other officers who were there before him saw only one glove. Think about what he knew at the time he went out to the South Pathway. He didn't know whether or not there were eyewitnesses to the crime that would say somebody else did it. He didn't know if there was going to be someone who said, I heard voices. They weren't his. They weren't Mr. Simpson's. He didn't know if the defendant had an airtight alibi and had maybe left on the 9 o'clock flight to Chicago. He didn't know any of that. What he could have done by planting evidence has been wrong and completely fouled up the solution of the case, because he's doing something like that without knowing anything about the case, subjecting himself, think about his own self-preservation, to an incredible felony. He's in big trouble, and all that has to happen is that an alibi is proven or an eyewitness comes forward, neither one of which he knows anything about. They could be out there for all he knows. He probably thinks they are. So think about that when you consider this theory of the defense. You know, I mean, it's like dismissing logic and reality and reason all at once, throw them out the window. Because nothing makes sense about that theory. Nothing from even Mark Furman's point of view. But I think if you look clearly at the evidence, if you look straight on and you use your common sense, you're going to see this. You're going to know this. You will. But the bottom line is, and I think that you'll reach the same conclusion, no one planted that glove. And you know why? Because they're his gloves. They're his gloves. Think about all the evidence you've heard now. Remember that he's a size extra large. The gloves are a size extra large. The glove at Rockingham is a mate to the glove at Bundy. They're a pair that are the same exact type purchased by Nicole on December 18th, 1990. One of only 200 pairs sold that year. Gloves that are cashmere lined. Gloves that cost $55. Rich man's gloves. Gloves that were exclusive to Bloomingdale's. Gloves that were not sold west of Chicago. Gloves that the defendant was wearing at football games from January of 1991, just a few weeks after she bought them, until the last football season before the murders. Now, you'll recall that there was a photograph that was shown to you. First of all, the receipt. There was a receipt that was shown to you that showed that when she bought the gloves, she bought 2 pair of gloves and a muffler on December 18th of 1990. And there was a photograph shown to you during one of the football games that I'm trying to remember the date of. I think it was 92. In which he's wearing a brown jacket, a brown muffler, and the brown gloves. Doesn't it make sense that when she bought the muffler, she bought it to match at least one of the pair of the gloves? And there he is wearing it. After she bought them, until the last football season before the murders. Now, you'll recall that there was a photograph that was shown to you. First of all, the receipt. There was a receipt that was shown to you that showed that when she bought the gloves, she bought 2 pair of gloves and a trying to pull up that picture for you. testimony that was taken on the on this photograph. You see the muffler, the jacket, the glove.
Mr. Farrell, is this?
I believe it's 614.
Thank you.
I think it was January of '92. If you need to have that reviewed for you, it's in the testimony. Okay. Now, I know that you recall the glove demonstration when the defendant put the gloves on, the crime scene gloves on. Now, he mugged for you, and he tried to act like it was real difficult, it was real hard for him, and almost impossible to get it on. Well, I'm sure it wasn't as easy as usual. He didn't have to ever wear them before over latex gloves. As Mr. Ruin told you, that makes it a great deal more difficult to put gloves on. And being old gloves, the blood that soaked into them soaked in and made them that much less stretchable. Because really the issue is stretchability, not so much size. If he'd had the chance to put them on, wear them for a while, they would have stretched back out. They would have been a better fit than they were. So it might have taken a little effort and a little time, but you ultimately would have seen that, of course, they do fit. And it's no different than an experience that we all have in our lives. You have leather gloves, they get damp a little bit, you leave them to dry, you don't wear them for a while, you go back, you put them on, they're tight. They're tight. You got to drag them on, pull them on, you wear them for a little bit, they stretch back out. And that's, again, that's common sense. That's something that we've all had in our life experience. But if you're really trying, of course, you can do it. But have you ever tried to put shoes on a child that doesn't want shoes put on him? Or a jacket on a child that doesn't want the jacket to be put on? You know, you can't do it. They're going to kick, they're going to scream, they're going to avoid you, they're going to struggle, they're going to squiggle, and it's not going to happen. Now, that's the same thing we have here. He doesn't want to put those gloves. He doesn't want to show they fit. But did you see how quickly he snapped them off? If they were so hard to get on, how come they came off like that? And they did. And I'll tell you something else that really struck me. If I were asked to put on the gloves, the bloody gloves that were used to murder the father of my children, I would not be laughing. I would not be mugging. I would not be playing games. I wouldn't think it was funny at all. Is that the attitude you expect, the laughing and the mugging? Putting on the bloody gloves that were used to murder the mother of your children?
Sustained. Move on.
Okay. The point here is that the person who wore those gloves wore size extra large.
In fact, let me see counsel's side vote. Why don't you go ahead and change your paper? All right, Ms. Clark, you may resume.
The point here is that the person who wore those gloves wore size extra large. If they had shrunk before that night, he wouldn't have worn them. What do you do with gloves that don't fit? You throw them away, right? That's why he was able to wear them. He would have brought gloves that did fit. That's what he would have done. Now, the testimony has told us that the gloves in evidence are smaller now than when they were new. So the issue, with all that has been done to them, blood-soaked, frozen, unfrozen, who knows what, the issue is how they fit at 10 p.m. just before the murders on the night of June the 12th. The issue is how stretchable they were then, before the murders, at 10 p.m. on June the 12th. And we know that those gloves fit him on the night of June the 12th because he wore them, the size extra large. The size you know fits him because he put on a new pair of extra large here in this courtroom. As Mr. Rubin said, they fit him beautifully. And he did that, of course, without the benefit of latex. And I say benefit sarcastically, latex to catch on them. So you have in these gloves all of the points that I've described and is shown on the slide. And another piece of the puzzle. Now let's move back down the walkway, the south pathway that is, that dark, narrow south pathway. And when he ran back down there, the defendant undoubtedly saw that the limousine was already there because it was pulled up facing into the driveway at the Ashford gate. It would be hard for him to miss. And he knew that he should already have been home. He was running late. And don't forget, you know, he's pretty shook up at this point. He's run into the air conditioner and banged into the wall. He's worried, got to be worried, about the fact that Cato's going to come out and worry and try to investigate the source of the noises. And he's got to get out of that south pathway because if Cato sees him back there, how's he going to explain that? How's that going to look? On the night of the murders of the wife and Ron Goldman. If Cato comes outside and sees him in that dark south pathway, what's he doing there? So he's got to get back in that house, and he's got to get back in a hurry. Which is why there was no time to hide the knife behind the guest house. He had to get out of there. Which is also why there was no time to realize that he'd dropped a glove. All right, so he goes into the house, which is where at the point that Alan Park sees him go in, which is a couple minutes after the thumps are heard by Cato. The defendant went upstairs quickly. He answered the intercom when Alan buzzed him this fourth time, I think. And he needed to collect himself. He needed to buy time. He left Alan sitting and waiting at the gate while he got ready to go. But when he took off his socks, he reopened the cut on his finger. And that's why you have blood on the bathroom floor. And under pressure to get out of there, get changed, and get going, because the limo driver's downstairs waiting, he left the socks on his bedroom floor. And in that one simple, careless act, gave us the most, possibly, single most devastating proof of guilt in the case. Because on that sock we found blood that matched Nicole Brown, blood that matched the defendant, and the blue-black cotton fiber. Now, I've already talked to you about the significance of the blue-black cotton fiber, fibers from the clothes he wore, clothes that we never found. What are the fibers that share the same microscopic characteristics as those found on the shirt of Ron Goldman, doing on his socks and on the Rockingham glove? Those are fibers picked up from the clothes he wore that night. And we never found them. He got rid of them. Now, the defendant's blood on that sock gave an RFLP match. Once again, putting him within 1 in 57 billion people. You'd have to go through 57 billion people to find blood type like the defendant's, as we found on that sock. So that's his blood on the sock. That's an identification. But that's not all. We found Nicole's blood as well. Now on this, on sock B, we have actually 2 stains for Nicole. Sock A, we have 1 stain. Now there's something interesting about these sock stains that perhaps was not made clear during the testimony. I want to bring it out now because it is very important to this notion of planting. Gary Sims testified, and when he did, he told you about the fine spatter that he found above, on sock A, that he found above the Nicole Brown stain on sock A. Little dots, I think he said there were like 10 of them above the Nicole Brown stain. And on sock B, he found little tiny spatter between the stains, 2 Nicole Brown stains on sock B. Little fine spatter, kind of like the little spatters you would get when you stepped in a puddle or a pool of blood. Mr. McDonald didn't want to talk to me about those little spatters. You know why? Because that little spatter proves to you that nothing was planted here. That blood got on his sock because he was wearing it at the crime scene when he was committing the murders, stepping in pools of blood. That's how that blood got there. And that's why you have that fine spatter. And as I've told you, Now, there was a smaller stain. I think there were 2 smaller stains of Nicole Brown that were only good enough for PCR testing. And there was 1 large stain that was good enough for RFLP testing. And the testimony gave us the fact that you'd have to look through 6.8 billion people to find the blood type of Nicole that was found on that sock. And of course, once again, that's identity. We have proven it's hers and only hers on this planet that was on that sock. All right. So with all of this blood evidence, what we have done, and fiber and hair, look at all we've traced, look at all we've proven. We have linked the defendant to the crime scene. We have linked the defendant to the victims. We have linked the defendant and the victims to his car. And that link has reached from Bundy into his bedroom at Rockingham. They are all interwoven by time, by space, by occurrence, by science. All linked. Now let's turn to the murders themselves. And in this section, I'd like to talk to you about the manner of killing. All right, in this section, I'm going to talk to you, I'm not going to start this way, but ultimately I'm going to talk to you about the law of homicide. What the people are required to prove in terms of proving that a murder occurred, what's a first degree and what's a second degree murder. Before I do that, I'm going to address some preliminary questions that, these are not questions the law requires us to answer, frankly. These are just kind of questions that you have, the things that you might want to debate in the jury room. I'd like to give you some ideas about these questions and ponder them with you for a little bit. But let me preface my remarks by saying that this has nothing to do with the elements of the crime that we are required to prove. In terms of our requirements of proof as to who did it and what they did, this has nothing to do with those, just so you know. Because this is a matter of, as I told you in the jigsaw puzzle, this is the piece of sky. But it's interesting, and it might be something that you're interested in. So in that light, I'm going to talk a little bit about it. First of all, how could one person do this without the victims being able to scream or escape? How long did this take to accomplish? What about these murders leads us to believe that it was committed by only one person? Okay, I'll start with the last question first. First of all, if someone else was involved, that certainly does not mean that the defendant didn't do it. It just means that he didn't get anyone to help, that he got somebody else to help him. It doesn't necessarily mean he didn't do it, though. I'm not saying that he did. I'm not saying that there was a second person there. I'm just saying that that alone doesn't mean anything. But secondly, first of all, if someone else was involved on a purely basic level of observation, look at the nature of the wounds inflicted to each victim. And I don't mean look physically because I'm not going to show them to you. But I mean, you can probably remember. The nature of these wounds, you know, as I watched the testimony, I thought, only one person could have done this because they killed the same way. The stab wounds to the back of the head, the coup de grace slash to the neck, the targeting of the neck that way. The style of killing is the same. That's just a layperson's observation, but it's kind of a practical, common sense thing. The murders look the same. You also heard a great deal of testimony concerning the murder weapon, whether it was single or double-edged, remember that? And whether all the wounds could have been inflicted by a single-edged knife. This is also information that goes to the determination as to whether or not you have 1 or 2 killers, although I must say, 2 killers could have 2 single-edged knives, because you can't tell I don't think you can, or there was no testimony indicating whether you could match a particular knife to a knife wound. Dr. Lakshmanan testified in this regard that all of the major wounds were inflicted by a single-edged knife. He indicated to you also that there were certain other wounds, lesser wounds, in which he couldn't tell whether it was made by a single or a double-edged knife. But it would seem to make sense that if all of the major wounds are made with a single-edged knife, why would you come in there then with a double-edged knife just to do the little ones? So it just kind of makes sense that a single-edged knife was used. But beyond that, scientifically, I think we had Doug Diedrich testify that he examined the damage in Ron Golden's shirt, and he determined that, and a shirt, of course, is less elastic than, and less messy, if you will, than flesh. And he was able to see the damage in the shirt and see that it was the knife, that the cuts in the shirt were made with a single-edged, very sharp knife, which tends to support and corroborate what Dr. Lakshmanan said. So the upshot of all that testimony is that to the extent that anything can be said based on what the wounds permit in a description of the murder weapon, it would appear to be a single-edged knife. Another indication that the murders were committed by one person comes from the blood evidence. And this is one of the few areas where there was really no dispute as to the accuracy or the reliability of the result. And here's a result we haven't yet talked about. Equals 100. All right, you see that blood drop on the bottom of the boot, ladies and gentlemen? It was, that's a sole of Ron Goldman's boot. That's a photograph taken at the scene at Bundy after the coroner arrived, because you can see he's lying on that sheet. All right, now that blood drop was tested, and it was a high amount of DNA. It was a high amount of DNA because, as you can see, it was dripped on a part of the boot that doesn't look that dirty, and it obviously dried on that boot. So the DNA did not degrade as badly as it did on the concrete. Again, that's a non-absorbent surface. It's plastic, so it was preserved better. Now, what the result of that drop was a mixture of the blood of Ron and Nicole. Now, what does that blood drop mean? First of all, obviously, that blood drop, and I think Henry Lee even testified to this, was dripped on the sole, and Ron Goldman was already down when it was dripped on the sole. How could it have dripped on the sole of the boot in that manner? Well, it had to have come from the murder weapon, from a knife. Those drops are dripped on, cast-off drops from the murder weapon, from the knife. And that means that Ron had already been cut badly enough to leave a quantity of blood on that knife, and it also means that Nicole had also been cut badly enough to leave a quantity of blood on that same knife. Because unless one knife has the mixture of blood of both victims on it, how can you get one blood drop from both victims? See what I mean? The blood of Ron and Nicole mixed on the knife, it dripped onto the boot, and that's why you get a blood drop with the mixture of their blood. And that shows you one murder weapon. Now, in addition to all of that, add the fact that you have virtually no evidence of the presence of a second killer. I mean, there should be something left, but there was really virtually nothing. Now, Dr. Lee tried to tell us about a second set of shoe prints, as you recall, but I think Mr. Boziak made it very clear what that was all about. The only real shoe prints found that did not match the Bruno Mali was that one shoe print that he saw on June the 25th, after police officers had walked through the crime scene, after it was broken down. You recall those photographs. 2 weeks after the crime, after cameramen had been on the walkway. I mean, what does that one shoe print mean? It means nothing, and it certainly has nothing to do with the murders. Now, what about the hair and fiber? Does that tell us anything in terms of whether or not it was one or two people that committed the murder? Now, as I've already mentioned, with respect to the hair and fiber, Mr. Diedrich testified to hairs, fragments of treated hairs that were not consistent with the defendants inside the knit cap or on the knit cap. He also testified, though, that he did not know how long those hairs had been on the knit cap, and they could be there for a very long time. But other than that, there was really no hair and fiber evidence that could be directly connected to the murders that was associated with anyone but the defendant. And by that, I mean hair or fiber on the victims or on the objects found at the crime scene that were directly and obviously involved in the murders, such as the glove, the knit cap. Dr. Lee testified to stray fibers and hairs that were in the dirt or that were on the envelope that was lying in the dirt. But stuff lying around in dirt could have been there for weeks, could have been there for months. And as I told you before, if we had found hair consistent with the defendants in the dirt there, I wouldn't be standing here and talking to you about that stuff, because so what? Show me something that is directly connected to the murders. And there was nothing. Nothing. And you know that if there was somebody else there, they had to leave something of themselves there. This was a struggle. Things happened there. Fur was flying there, as you can see. Now, while I'm talking about hair and fiber, there's one more piece of evidence that tells you that the defendant acted alone, and that is this. You recall that Mr. Diedrich testified that he found Mr. Diedrich said he found hairs consistent with Nicole Brown's on the shirt of Ron Goldman, and we know from all of the evidence that's Nicole's hair on his shirt. Think about how that happens. If the killer kills Nicole or attacks Nicole in the initial attack, and I'll get back to that later, and he touches her hair, touches her head, he gets her hairs on him, goes over to attack Ron, those hairs will be transferred. And Mr. Diedrich talked to you about how transfers occur. Logically, her hairs would get on Ron's shirt if the person who attacked Nicole then went over to Ron. There would be no reason for the transfer to Ron's shirt of Nicole's hair if two people were involved in these murders. Logically speaking, two people are involved, one takes on Ron, one takes on Nicole, but you don't have one person attacking Nicole and moving over to attack Ron if two people are there. No one wants to take their time committing murder. As a matter of common sense, you're going to get in and you're going to get out. And if you've got two people available to do it, one's going to take one and one's going to take the other. And you're not going to have that kind of movement of hair from Nicole to Ron. So it's very clear. The crime scene really makes it very clear that there's evidence of only one killer, and all of that evidence establishes that that is the defendant. Next question, how long could it have taken? On this subject, there really is some agreement. There is agreement that all of these wounds could have been inflicted very, very quickly. Even Dr. Bodden didn't disagree with that. Dr. Lakshmanan said it could have been just a few minutes. Now, when you realize, you look at this crime scene, look at what you have, look at where you have it. It is apparent from the evidence at the crime scene that Ronald Goldman was taken by surprise. And I'll get to Nicole in a minute, because there's evidence with respect to her too. But first, let's take Ronald Goldman, because that's the one who struggled. You see, do we have that picture? Thank you. Okay, this is 43E, Your Honor. All right, you see the envelope? And it's just inside the gate. Now, you remember, because you were there, how small that area is, in that caged area at Bundy. It's very, very, very tight. And that envelope is virtually with one step in the gate. It's dropped. And we have blood drippings on the envelope that indicate that it was dropped and then Ron bled, dripping onto that envelope. That indicates surprise. Show you in a moment where the keys were found as well. He dropped his keys also. Now, I know a lot of suggestions were made here about how you can use keys as a weapon. I don't see how that really makes any sense, frankly. How do you use keys against a 6-inch sharp knife? And how do you see any evidence there that he even had them in his hands long enough to think about that? Those keys were dropped, and they were dropped right inside the gate. And I'll show you the photograph of where they were found. People's 56C. See the keys right by the gate? Now those are a little bit, if this is the gate right here, if you step inside, it's a little bit down to my right as I'm gesturing. But again, they're right inside the gate. They're right inside. Dropped. Ron is taken by surprise. Now, Dr. Lee tried to say that the struggle with Ron was not a short struggle. What does that mean? What does that mean? More than a minute? More than 5? The fact that Ron struggled is clear. But what is also obvious is that someone who gets stabbed and is flailing about can get blood all over the place as he's struggling to back away from his attacker. And that happens very quickly. I mean, you can imagine in your mind's eye somebody just flailing about, trying to get away from their attacker. A big person with a knife in a very, very dark area, very confined space. He hasn't very far to go, ladies and gentlemen. He's got only a few feet to move. And he's backed into a corner like that. Where's he going to go? He flails backwards, trying to avoid his attacker. A number of the contacts that you see, the bloody contacts on the fence, are made at once as he's flailing. And that's what you see on that fence. You see a young man bleeding, backing and falling, vainly trying to get away from the defendant, who has him cornered in a cage and is coming at him with a very long knife. Now I'm going to talk in a little more detail about how one person could do it. How? Dr. Lakshmanan spoke of the fact that Nicole suffered only two defensive wounds. One to the back of her left hand. I think it was one to the right of her palm. She struggled very little. As Dr. Lakshmanan told you, she was rapidly, that's what he said, rapidly incapacitated. She was disabled very quickly. There were stab wounds to the back of her head that indicated movement, perhaps as she tried to run, stabbing her in the back of the head. An abrasion to the right eyebrow indicates that she was pushed or fell into a hard surface, such as the wall or the stairs. She was stabbed in the left side of the neck 4 times. There was some movement shown on her part with respect to at least one of those stab wounds in the left side of her neck, which indicates there was still some effort at resistance. And now, most importantly, Dr. Lakshmanan found evidence of a scalp and brain contusion caused by a blow to the head done by either a fist or the base of a knife. A contusion that was likely to cause unconsciousness, which in fact we know it did, because when the defendant cut Nicole's throat for the last time, There was no indication of any movement on her part. It was a clean cut. That final coup de grace had smooth margins that indicated no resistance on her part. And there's a little bit more evidence of that I'll talk about later. But what's very important about these early wounds to the head and neck is that Dr. Lakshmanan told you there was evidence of bleeding in that brain contusion that showed that she lived after the infliction of those wounds for at least a minute and maybe more. Likely in an unconscious state, certainly disabled. At least a minute, maybe more, before the final blood throat cut was delivered. Please cut the feed, runner. Now look at the upper step, ladies and gentlemen. You can see that she bled out on that step above her for a while before she came to the final spot at the foot of the stairs. And Dr. Lakshmanan testified that Nicole was unconscious when the final throat cut was administered and she was put down at the base of those stairs. If she lived for at least a minute, if not more, after she was hit on the head and struck unconscious, before her throat was slashed for the last time, and she was up on that upper step where you see the first pool of blood, what was the defendant doing during that minute or more as she was laying unconscious or incapacitated on that upper step bleeding? What was he doing before he came back to administer the final coup de grace? With Nicole disabled, the defendant had ample opportunity to deal with an unsuspecting, unarmed Ronald Goldman who had just come to do a favor for a friend. And I remind you of the testimony of Dr. Lakshmanan in which he described the very narrow and confined space, the cage in which the defendant cornered him. A cage that left Ron nowhere to run and nowhere to hide, literally. The defendant had all the advantage, no matter what Dr. Heisinger says. He talked about Tarzan's grandfather. He's built like Tarzan. He is built powerfully. And even Dr. Heisinger said, admitted, that whatever the defendant's disabilities may be, they did not prevent him from performing the actions necessary to commit these murders. And the defendant had the advantage. He had the advantage of size. Ron Goldman was only 5'9", I think 175 pounds. Nicole Brown, 5'5", 125 pounds. The defendant, 6'2", 210 pounds. He also had the advantage of the knife. He was the only one armed in this combat. He was the only one. And he had the advantage of surprise. He knew what he was going to do, but they didn't. And don't forget, too, the adrenaline factor. That's real important. That's important. And Dr. Heisinger talked about that, because adrenaline pumps you up. And even Dr. Heisinger talked about how football players get pumped up. And you know they have to. They've got to go running through these huge men. I've never seen men that size on the football field. You've got to be able to knock them down, run through them, and you've got to get pumped. You've got to have a killer instinct to do that. And that's what the defendant did. And that's what he did that night. And the defense can talk all they want about this new rare form of arthritis the defendant supposedly has that allows him to swing a golf club, lift a heavy set of golf clubs in that heavy golf bag. You'll have it back there in the jury room. You'll see what I mean. Lifted it not once but a few times that night and carry heavy suitcases. That curious form of arthritis that somehow prevents him only from doing the movements required to stab and murder these people. But that's not what Dr. Heisinger, his witness, said. He could do it. He could do it. Now let's talk about the attack of Ron. Ron was attacked with the defendant behind him. That much is clear. The wounds inflicted to the neck, those control wounds, and I'll talk a little bit more about that, and some of the other stab wounds. And Ron struggles. Unlike Nicole, he's not so easily put down. He struggles, and he grabs. The defendant who's holding him from around the neck with his left hand and holding the knife in his right. Ron is struggling, and he's grabbing at anything he can, and he's grabbing at the hand that's holding him, and that's how the glove comes off. And by the way, that's why the right glove doesn't come off, because the right glove, the right hand, is holding the knife, holding the glove in place. But from that point forward, after the defendant first attacked him, Ron's death was not a matter of if, it was just a matter of when. And Ron was totally on the defensive from the start, trying to ward off the knife and to back away. And in the process, hitting the fence, the trees, and everything around him in a desperate effort to survive. And all of this had to have happened very quickly. And I say this as a matter of common sense. It didn't take Ron Goldman and Nicole Brown more than a few minutes to be overcome and slashed to death. And that's not really surprising. Think about it. a boxing match, each round is what, 3 minutes? And this is with men that are both prepared, ready to do battle in good condition, who are not taken by surprise, who are prepared to do battle. And we know knockouts occur in the very first round. They certainly happen within a minute. And that's with trained professionals. Same thing with martial arts matches. Very quick. All right, next question. Why did he leave the cap and glove? This one's probably very easy. It was late. He had to catch a flight. This took longer than expected. Ron Goldman was not expected at this scene. He was not supposed to be there. But it is only because of him, because of the struggle that he put up, that we have the cap, we have the glove, and we have all this evidence. Ron's shirt, the blood. Because of the struggle with Ron, we have all of this evidence. But I'm not saying that the defendant was not aware as he was leaving the scene that he knew he had lost evidence, because he was. There was evidence given to you by Mr. Boziak, who testified that he saw hesitation shoe prints down the Bundy walk, that he saw evidence that the defendant walked down the walkway, stepped back against the north wall, and stepped out as though to look back at the crime scene. And what that shows you is evidence that I've lost my cap, I've lost a glove, but he's thinking about going back but doesn't dare. Time is running out. He might be seen by someone. The longer he remains, the more likely to be detected. And probably the dog howling already. And so he has to leave. Don't forget, too, that the glove and the cap are in complete darkness underneath that plant, in that very dark area in the front of Nicole's condominium. Now, I know that I have not explained every move that was made by the defendant, which blow came first, which one came last, and which one came in the middle. The law doesn't require us to do so, and of course there's a simple reason for that. Because short of a videotape, we very rarely know exactly how any crime occurred. People who commit murder obviously try not to do that in public and where everyone can see them. Their victims can't talk and they can't tell us what happened. We have to look to the physical evidence, and we have to use our common sense and our reason to make reasonable inferences to determine what happened to the best of our ability. And even if we had a videotape, ladies and gentlemen, it wouldn't show you everything. What happens before the tape starts? What happens after the tape ends? And what if, and of course a camera only picks up what's in its lens. So if you saw, for example, a videotape of this case that had Nicole, that was able to focus on Nicole, but not pick up Ron, and you saw the defendant killing Nicole and slashing her throat, and then he stepped out of range to attack Ron, would you thereby conclude that he didn't kill Ron? No, of course not. Of course not. So the law does not require that we prove how a murder was committed, simply because, in that case, we'd have very, very few convictions for murder. The law requires that we prove that a murder was committed, who committed it, and what degree of murder it was. So the order of wounds makes very little difference. It doesn't answer any of those questions that we're required to answer, and that's what we're here to determine, is those questions that the law asks us to prove. But there is one aspect of the nature of these murders that is a very telling point when you think about who did it. When you look at these pictures, ladies and gentlemen, you see rage, you see fury, you see overkill. This is not the mark of a professional killer. These are not efficient murders. These are murders that are really slaughters, that are personal. And in that respect, they reveal a great deal about who did them. No stranger, no Colombian drug dealer. A man who was involved with his intended victim. One who wanted to control her and failed. And in failing, found the one way to keep her under control where she could never slip out of it again. And that man is this defendant. I have one more to go, so.
All right, ladies and gentlemen, we're going to take our mid or late afternoon recess at this time. Please remember all my admonitions to you, and we'll stand in recess until 6 o'clock. All right, thank you. The Simpson matter. And let the record reflect that we've been rejoined by all the members of our jury panel. Good evening, ladies and gentlemen. Ms. Clark.
Thank you, Your Honor. Good evening, ladies and gentlemen. Well, we're really hanging out together today, aren't we? I hope you all had a real good dinner. I'm going to conclude my remarks for you at this point in about I don't want to say exactly what time. Lawyers are always wrong, but I really think it'll be about half an hour, okay? And I'm going to talk about the law of premeditation, and that means first and second degree murder. Let me tell you briefly what I forgot to tell you in the very beginning. In all criminal cases, because the people have the burden of proof, I argue to you first, and Mr. Darden will then argue to you. That's the prosecution. Then the defense will argue. Then, because we have the burden of proof, we get to argue again. We get the last word, so to speak. But it's fair because it's our burden. Okay, so you're going to hear from me again. I'm making now to you the bulk of my remarks. I hope and pray not to be taking as much of your time when I stand up to speak to you again at the conclusion of the case. So I just wanted to let you know that that's the order of things. That's the way it goes in criminal trials. All right. So let's talk about the degree of murder. Is it first or is it second degree? Because you will be asked to determine this question also. And you'll have the law of first and second degree murder back there. And if I can give you a hand in stepping through the law to understand how it applies to the facts, I'd like to try and do that now and be of some help to you. The defendant is charged with 2 counts of murder. And you're going to decide whether they are first degree or second degree. And in order to do that, what you do is you apply the law to the facts. That's what a judge does. And it's actually much simpler than it sounds. And let me start with the basic law of murder. Legally speaking, what is murder? Some written forms back in the jury room with you, so if you have questions, you want to talk about them, you can go over them again. All right. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Section 187 of the Penal Code. Okay. In order to prove such crime, each of the following elements must be proved. Number 1, a human being was killed. Ronald Goldman and Nicole Brown were obviously human beings. Element satisfied. 2, the killing was unlawful. And what they mean by that is that there's no legal excuse for the killing. That's not even an issue here. 3, the killing was done with malice aforethought. Okay, that's the issue. Let's talk about that. Malice can be either express or implied. In this case, the only issue we have is express malice. What is express malice? Express malice aforethought means that a person had an intent to kill where there was no lawful reason to do so, and malice does not require any hatred or ill will of the victim. So, for example, regardless of whether the defendant liked or disliked Ron Goldman or even never knew him, malice is shown if the evidence shows that he intended to kill him. Now, how do you determine if there was an intent to kill? We're not talking about premeditation. We're talking about an intent to kill. How do you prove that? Look at the pictures. This one is proven easily when you look at the nature of the injuries that were suffered by the victims in this case. The unlawful intent to kill is very obvious. These victims were virtually hacked to death. So you have malice shown in the nature of the injuries, the nature of the wounds that were inflicted upon them. So malice, express malice is shown. Just look at the pictures. Aforethought, malice aforethought, what does that mean? That just means that the intent to kill was formed before the actual killing occurred. It's not an afterthought. That doesn't mean premeditation or deliberation, and we'll talk about that in a minute. And again, with the nature and the number of the wounds that were suffered by these victims, it's very obvious that the killer went to great lengths to disable and kill them with the throat-slashing wounds alone. The preformed intent to kill is very clear. In fact, malice aforethought in this case, again, it's proven so clearly just with the coroner's photographs and the pictures of the victims at the crime scene where they were found. So you look at those photographs, you can see that there was a preformed, even if it was just a second before, intent to kill these victims and a great effort made to kill the victims with the nature of the wounds. And there you go. We've applied the law to the facts, just like you'll do back in the jury room, to determine what was done. Let me give you an example aside from... Let me give you an example. This was a case I remember from a while back. A very simple example of second-degree murder. In this example, a young man was standing on a street corner with his girlfriend. Another young man came and drove up to him on a bike, rode up to him on a bike. He asked the young man on the corner, "Hey, where are you from?" The young man on the corner responded, "I'm not from around here." Young man on the bike pulled out a gun, shot him to death. Second-degree murder. In that example, you have a preformed intent to kill, although no evidence that the young man planned to kill when he first rode up on the bike. But it was preformed in the second that the young man on the corner said, "I'm not from around here." Second degree. because when he pulled out the gun, he clearly meant to kill, even though it was what you'd call a rash impulse. That's second-degree murder. At a bare minimum, in this case, at the very, very, very least in this case, we know we have second-degree murder. That's the very least that we have. But now we ask, do we have more? Is there more? Do we have evidence that the murders were of the first degree, that is premeditated and deliberate? In asking this question, what we're really asking is whether there is evidence that the defendant weighed and considered the question of killing and the reasons for and against the choice, because that's what we're talking about in terms of premeditation. The answer to this question, just like all the others, comes from the evidence. We look to all the evidence in the case, and we ask, is there evidence of planning? Is there evidence of premeditation in the manner of killing? Is there evidence of preparation for the act of killing? I'll address all these questions right now in the course of the argument, but I can tell you that the answer to these questions is yes. I'll briefly discuss the law with you, and then I'm going to show you how the evidence can be applied to the law to answer all of the questions that, yes, we do have premeditated and deliberate murder. First of all, premeditated. Let me see, I think we have the jury instruction for this. Right now. That's okay, I'll just tell you. Premeditated is what it sounds like. It does mean considered beforehand. And it's important to remember here that there is no time requirement. The jury instruction states that the law does not undertake to measure in units of time how long the thoughts of killing were considered before they ripen into something that we call premeditation and deliberation. And the reason for that is very simple, and the law and the jury instruction you have will tell you so. Circumstances vary in each case. Each case is unique, has a unique set of facts, and each defendant is unique and has unique thought processes. And so you cannot say, well, 3 minutes is not enough and 5 minutes is plenty. You can't do that. So it's not the consideration in terms of how much time, because you can premeditate within just a few minutes, even seconds.
This is 8.20.
Thanks, Neha. Here's what I was saying. You'll have this in smaller form, and it won't be highlighted, but you'll have it back in the jury room. This is the area I was directing your attention to. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. And that's common sense. I mean, you'd think that, wouldn't you? So the true test is not the duration of time, but rather the extent of the reflection. So even if you want to say, for example, that premeditation and deliberation happened in a mere few minutes or seconds, you're going to have to show that during that time there was deliberation. Deliberation is really the issue. What do we mean by that? Under the law, deliberation means that after giving careful thought and consideration, weighing the considerations for and against, the killer decides to and does kill. And that's really what the crux of the matter is in a premeditated and deliberate murder. Can you show that kind of weighing and considering of the consequences? And this is to be contrasted with a second-degree murder, because in second-degree murder, you have what is known as just a rash impulse. And do we have that? Oops, sorry.
Thank you.
All right, here's second-degree murder. I just wanted to give you a chance to contrast it, okay? Murder of the second degree, the unlawful killing of a human being with malice aforethought. We talked about that as intent to kill. When there is manifested an intention unlawfully to kill, there's an intent to kill, but the evidence is insufficient to establish deliberation and premeditation, okay? So you have basic murder, murder of the second degree, and then if you have more, if you have premeditation and deliberation, you have murder of the first degree. To give you an example of first-degree murder, let's add to the example I gave you previously of the young man on the bike, goes up and he shoots the young man standing on the corner. To make this a first-degree murder, this time assume the following. Assume that the shooter knows who his intended victim is. Assume further that the shooter is a member of a gang and that the intended victim is a member of a rival gang. Okay? The young man standing on the corner, his gang recently killed somebody in the kid on the bike's gang. Kid on the bike knows this. He sees the victim on the corner, recognizes him as a rival gang member, a member of a gang that just killed a member of his gang, and he decides, payback time. We're going to get this guy. We're going to show him. And it's my time to do it. And now, knowing who the victim is, knowing what his motivation is, knowing that he's going to pay him back, he rides up to the young man on the corner, goes up to him, pulls out his gun, shoots him at point-blank range. There's first-degree murder. He's got a premeditated and deliberate idea of what he's going to do and why he's going to do it, and then he goes to and does do it. Now, in this example, we see the evidence of planning. And we see the cold, calculated decision to kill that is all accomplished very rapidly when he sees and recognizes the victim as a member of the rival gang. Here's a non-criminal example of premeditation and deliberation. This is something that, to show you that we make decisions that are premeditated and deliberate every day. Let's say that you come downtown with some of your friends. You come downtown to have dinner one night. Go into the restaurant, you have a good time, hour gets late, and by the time you step out of the restaurant, it's already, the streets are almost deserted. Very, very little traffic on the streets. You and your friends walk to the corner, and when you walk to the corner, you see that the don't walk sign is flashing. But it's late, you're tired, you don't want to wait. Don't walk sign is flashing. You step out, you look this way, you look that way, you don't see any traffic, you cross the street. As you step off the curb, that was a premeditated and deliberate decision. Didn't take very long, but you weighed the consequences, pro and con. You said, well, I could get in trouble, there might be an officer around, I might get busted for jaywalking, but then again, it doesn't look like anybody's there, and it's probably okay. And you cross the street. Premeditated and deliberate decision. So you can see why it doesn't take long. It's not the length of time, it's the quality of the time spent. Okay, so that's first degree and second degree murder. Second degree, a rash impulse, intent to kill with no premeditation and deliberation. First degree murder, premeditated and deliberate, a weighing of the consequences, pro and con, and a clear and deliberate decision to act, and then the murder. Now the question is, do we have evidence of the premeditated and deliberate type in the murders of Ron Goldman and Nicole Brown? As I've told you, the answer to this question is yes. Now, I'd like to break down this evidence into three categories. For me, this is the easiest way to analyze a case to see if there is premeditation and deliberation, and I hope it works for you too. Here's the first category, is motive. Do we have motive? Now, under this category would fall the subject matter that Mr. Darden is going to address, so I'm not going to discuss it with you other than to mention that the past episodes of domestic violence between the defendant and Nicole, that evidence is evidence of motive. I'm not going to say any more about that because Mr. Darden will address it. The next category is planning activity. What did the defendant do that shows us that he was planning to commit murder? Okay, now I'm going to come back to those questions I asked you to bear in mind early in the argument. Remember when I asked you, think about this, why did the defendant go out and ask Cato for fives for the sky cap to break the hundreds that he had if he was already going to go out and eat? Remember I asked you that in the beginning of my argument. The significance of that, of asking Cato for the fives, to asking him for change, when he already knew he was going to go out and get something to eat and could obviously get the change at that point. He obviously didn't need Cato to give him those fives, so what was the point? And even when he went out with Cato and he got the change back, he didn't keep it. So getting change from Cato was not the point. And none of his conduct is consistent with what he's telling Cato. None of it makes sense unless you look behind the words. What was he doing? What he was doing was he was setting up an alibi with Cato. He's going out to see Cato so that Cato can say that he saw him. Then Cato can later say, I saw the defendant. I saw him at 9, 10 after 9. He told me where he was going. He said he was going to get something to eat. So if it is discovered that his whereabouts are unknown during the time of the murder, he at least has someone to say, well, wait a minute, he told me. He has a non-criminal explanation for where he was. So he comes up with a pretext of needing change for the sky cap. And it's a good way to remind Cato that he's going to be out of town, too. He'll have Cato remember that alibi also. I need change for the sky cap. Unfortunately, Cato stepped in his way. Cato invited himself along. And the defendant would have been hard-pressed to refuse. Because think about that. If Cato's going to be his alibi to tell anyone who later asks that I saw the defendant at thus and such a time, and then he said he was just going to go out to get something to eat, and then he says, you know, but I tried to invite myself along, but he wouldn't let me go with him, then you have further evidence of consciousness of guilt. then it's going to look suspicious. Why did he let him go with him? What's the big deal? I mean, he lets him live there. So the defendant agrees. Take Cato with him. This unexpected development, however, eats up time for him, time that he could have had out thinking about what to do, something that he was getting ready to do, getting ready to commit the murders. So instead of going to a real restaurant, which he had the time to do, at 10 after 9, the limo isn't going to get there till 10:45. Even if you assume there's some packing to be done for a one-day trip, how long does that take? They could have gone to a restaurant. But no, they didn't. They went to McDonald's, and they went to a drive-thru, the quickest way you can possibly think of to get some food. And he went there in the Bentley. Now think about that. Why take the Bentley? Why not take the Bronco if all you're going to do is go to McDonald's?
You don't have time to go to a restaurant,
Unless there's
Marcia.
something in the
You're
Bronco
wrong.
you don't want Cato to see. The knit cap, the knife, the gloves. If Cato sees those on the night that he intends to commit those murders, before he has committed them, and the police get to him and say, what did you see? Where were you? I mean, what did happen? What happened in this case? He's going to say, that knit cap. I know where I saw that. These things have to pass through his mind. Now, he's got these things in the Bronco. He doesn't want Cato sitting in that Bronco with him. So they took the Bentley. Now, once they got their food at McDonald's, the defendant eats his in the car all the way home. Why do that? You got plenty of time to take it home, eat it in your house, relax, live a little. It doesn't have to be rushed like that. But he eats it quickly. Why? Because now his time has been eaten up by Cato coming along, time he doesn't have. Cato saves his. And it was interesting because he complained about being tired. It was about, what was it, 20 after 9, 25 after 9? They were in the car on the way back, I think it was. And he complained about being tired, and Cato said, well, why don't you take a nap? He said, well, I've got no time. When I heard that, got no time, the limo, it's 9:25, the limo doesn't come till 10:45. You got time to lay down, unless you're planning on doing something else. But what was really telling was after they got back, when they both got out of the car, and Cato walked straight for the house, and the defendant stood there by the Bentley, not moving, watching Cato. Why do that? Why do you stand there and wait? Why not go in the house? Why not get back in your Bentley or get in the Bronco? Why do you wait for Cato to get out of sight? Unless you don't want him to see where you're going. Unless you have it in mind that you're not going to go back in the house. You don't want to take the time to do that. And you don't want him to see you going to the Bronco. Now, there's much more evidence of planning. Planning that you see at the crime scene itself. And in that, I mean the defendant wore dark clothing. The dark blue black cotton sweatsuit that Cato described, perfect in the nighttime if you don't want to be seen. The dark blue black cotton fibers that were found on Ron Goldman, the socks, the Rockingham glove, the fibers of the clothing he wore. The watch cap and the gloves. It was June the 12th, the summer night. Why do you need these cashmere-lined gloves and a watch cap on a summer night? Unless you're going to commit a crime. Unless you're planning, unless you're preparing to commit a crime. Gloves are easy. Why wear the gloves? Fingerprints. You don't want to leave fingerprints. And he didn't. You heard from the print people he didn't. Watch cap. A partial disguise. If he has to walk around the house, if he's going to be standing at the front gate, he doesn't want someone glancing to make the immediate connection. He doesn't want someone to see exactly who it is right away. Now, he doesn't intend to be there but a minute. But a watch cap over that head is going to make somebody, that doesn't look like something that he would wear, and it throws someone off. Now, those items alone show clear evidence of planning activity, planning for a murder, preparation. But there's more. There's also timing. And by that, I mean, we know that the children were asleep at the time these murders were committed. We know that from the evidence. But who else would know when the children were going to be in bed? Who else would know when they would be safely out of the way? Who else would know when Nicole would be home alone with the children? Who else would know the perfect time to attack and get Nicole without the children being in the way? The defendant. And that not only shows premeditation, it also shows identity. Who did it? Now, there's one more thing that shows evidence of premeditation and deliberation, and that's the knife. In the inventory tape that you have in evidence, the defendant's closet is shown. And it's shown that he had in that closet a gun. He had a gun, but he chose a knife. And this choice is evidence of planning. A gun makes noise. A knife doesn't. Particularly if your intended victim is half your size. A gun is registered. It can be traced. And bullets can be matched to guns. And even if you get rid of the gun, the type of bullet can be determined. It can be determined to have come from the type of gun you used to have. So if you get rid of the gun, it's looking even worse, almost, than if they catch you in possession of it. Suddenly don't have the gun after your wife was shot to death, and a bullet that could have come from that gun. But not a knife. A knife can't be identified to the exclusion of all other knives in making this wound or that wound. You can't match a knife to a murder. A knife isn't registered. All of these things make a knife a better weapon of choice than a gun. But maybe more than all of that, a knife is up close and personal. And that's the kind of murders these are, ladies and gentlemen. These murders are up close and personal. If your desire is to vent your rage on someone, a gun is far too sterile. It's far too removed. But a knife, it's lethal, but it affords the opportunity for the expression of violence, power, and control at very close range. The choice of a knife is evidence of planning, and it too is also evidence that the defendant is the murderer. Now, there's more evidence of premeditation and deliberation in the nature of the wounds themselves. Let's start with Nicole. As I previously discussed, Nicole was incapacitated very quickly. She had little, if anything, in the way of defensive wounds to her hands, and she had no opportunity to defend herself. Likewise, the 4 wounds in close proximity on the left side of her neck, very close to one another, they indicated very little resistance, and they suggested that she was controlled or otherwise incapable of moving away to avoid being stabbed. And the gaping neck wound, the final coup de grace that nearly decapitated her, that is classic evidence of a cold, calculated, premeditated murder. Now recall that this was a wound that was 3.5 inches deep, severed both carotid arteries and both jugular veins. This wound was so deep that the tip of the knife took a 1/4-inch gouge out of her vertebrae. As you recall, and I've discussed it before, when this wound was inflicted, Nicole was incapacitated and helpless. There was no resistance indicated in the wound. The edges of the wound were smooth. And I told you there was something else that indicated she was unconscious, and that is this. The evidence of her knuckles, unbloodied in an area where blood had already pooled around her, showed that she was incapable of raising her hand to protect herself, incapable of raising her hand to try and ward off the knife or the hand that held the knife. No, the knuckles stayed in contact with the pavement and didn't get the blood on them that they would have gotten had she been able to raise a hand to do something to protect herself. And it's further evidence of her unconsciousness at the time that that final slash was inflicted. Now, you remember, as I indicated to you earlier, the testimony indicated that the bleeding into the contusion in her brain showed that she lived for a minute or more before that final throat wound was administered to her. Now, that final gaping wound in her neck was inflicted upon an unconscious victim, or at the very least incapacitated, is clear evidence of a cold and calculated decision to kill. When a victim is already incapacitated and the defendant goes back to her, pulling back her head, she's lying there basically unconscious. He pulls back her head and he slashes the throat to such a degree that she's nearly decapitated. That was a cold and calculated decision to kill, to make sure she was dead. And it allows for no other reasonable inference. Now, Ronald Goldman. Now, once again, a very significant point with respect to Ronald Goldman. As with Nicole, the neck is the target, once again. And we know that from the neck wounds on Ron described by Dr. Lakshmanan. Why the neck? Why is the neck the target? Because it's a sure kill. It's something we've all heard about. Go for the jugular. You go for the jugular because you cut it, you slice that neck, that person's dead. That's a sure bet. That's a sure thing. And the fact that the neck is the target for both victims indicates to you also a cold and calculated decision to kill. That is the epitome of a premeditated murder. Now, let me point out, with respect to Ron, you have those two wounds. You recall those two lines across the neck, almost parallel to each other, with very little bleeding in them, that Dr. Lakshmanan indicated were inflicted early on in the struggle. Their evidence, and the reason they're important, is that they're evidence that the defendant controlled Ronald Goldman, controlled him to the point that he could hold him and draw the knife across the neck in lines that were nearly parallel to each other, holding Ron from behind him, left arm around him, with the right hand drawing the knife. And Ron struggled to break free of that control. And because he struggled and because he put off the fight, it took the defendant a little longer to incapacitate him than it did Nicole. And you've heard the cross-examination, you've heard the defense attempt to say that Ron Goldman fought with his attacker. Ron struggled, but it was not a struggle with the defendant. It was a struggle to save his own life. It was a struggle to escape. The defense wants you to believe that Ron fought, that he punched the defendant. This was not a fight. And the reason we know this was not a fight was that Ron's palms are cut. For your palms to get cut, your hands have to be open. If your hands are in a fist, you're not going to get your palms cut. It's just as simple as that. And Ron's palms were cut because his hands were up as he was trying to ward off the knife, trying to defend himself. And those abrasions on the back of his hands that were made so much of, they are fully consistent with Ron flailing back, hitting the trees, hitting the sapling, hitting the fence. There were so many areas for him to hit and get those abrasions. Abrasions that are not at all consistent with a fist hitting a face or a body part. And if you look carefully at those photographs, you'll see what I mean. A fist hits a face and you're going to get more than just one little scratch in one little area. You're going to get much more than that. You don't have it here. And the reason you don't have it here is that you have evidence on the back of the hand that shows Ron Goldman falling backwards, as you know he did by the blood on the fence behind him. There's no question about that. And you have his blood on the stump that he's around. You have a lot of evidence to show you what happened here, and it wasn't a fight. This was not a fight. To call this a fight is to call drowning swimming. The sheer number of wounds suffered by Ron as he struggled to pull away, to escape, the sheer number of these wounds is consistent with only one thought. Ron Goldman must die. But beyond that, there's evidence in the wounding that the murder of Ron Goldman is of the first degree.
I just really, really, really wish she would have said all of this during the trial. You know what I mean? None of this was said during the freaking trial. I guess closing statements is still the trial, but you know what I mean. It's just frustrating because we just spent over a year just listening to a bunch of bull. This is what we needed to hear. This right here. If we would have heard about the murder during the murder trial, but we didn't. I think they talked about it once or twice, maybe in passing by accident. Like, okay, I guess we must mention the fact that someone was murdered today. But it's this right here, this closing statement is the most frustrating because it's not like they didn't know what to say. They obviously know what the jury needs to hear. Why didn't they present evidence for this? But we did. We showed evidence. No, you didn't show evidence of that. You showed a bunch of medical doctors saying all this crap that means absolutely nothing. Just nothing. Yes, Amy. Yes, and they're great. And it's just completely pissing me off. Like, I'm triggered right now. Shook. Because this should have been every day. Every day the jury came in, Marcia should have somehow put in their faces how these two people were murdered. Right in their faces. It should have been every day. But no. Every day we were just bombarded with bull. I wonder what I mean, she's not stupid. She's not a bad prosecutor. She knows how to argue. She knows what to say. I just don't understand why they weren't just a little bit wrong. They were a year wrong. Like, why did they do what they did? I don't know. I do not know. I can't imagine that happening today, which is good, you know. Anyway, we're going to move on with this tomorrow. Don't worry. What is today? Before I say that, yep. Today's Tuesday. So we're gonna get more of it tomorrow, guys. Don't worry. Thank you so much for coming out today. Thanks for watching the OJ Simpson trial with me. Nan, it's good to have you back. Really, really, really good. Anyway, I'll see you guys again soon. Come out Wednesday night. Come and watch the live stream Wednesday night. It's spicy. Bye, guys.